two before we start, just so we can let hopefully have more people join. Right. Just quickly before we start, Marie, do you know when Karen is going to be joining us?
I spoke with her this morning and I thought she was going to be joining us at noon.
Okay. All right. Do you mind going first if she isn't on yet?
Well, she was the one that was supposed to be giving the presentation.
That's what I thought. All right. Then we'll just wait a couple more minutes to see if Karen joins us for purposes of the presentation.
Mike, I'll send her a little message to see if she's jumping on, okay?
Great, thank you.
She was sent a Zoom invitation, right?
Yes, we believe so.
Oh, there
And there
she
she
is.
is. Okay, then I'm going to go ahead and call the November 14th meeting of the Injured Employee Partial Permanent Disability Payment Working Group. Any remarks from my co-chair?
Thank you, everyone, for taking some time out of your day to join us and have this lively discussion. And I look forward to the presentation.
Okay, thank you. Can I have a motion to approve the minutes from the October 24th meeting?
So moved.
Second.
Representative Acker, second by Representative Conley. Any discussion, changes, corrections, additions, subtractions?
Very comprehensive, and I appreciate those the work done on those minutes. Just excellent.
Great, thank you. Okay, all in favor, say aye. Opposed? Motion carries, minutes approved. Before we get into our presentation, I did want to acknowledge that attorneys Schaffner and Drapo did send some permanent partial disability benefits, proposed changes. We're not going to take those up today, but we will send them to you after today. So I did want to spend today spending some time on the vocational rehabilitation application and process. And with us from Workers Rehabilitation Services is Karen Sargent. And Karen, I will turn the floor over to you.
Thank you. Good morning. It's great to be with everyone, or good afternoon, rather. Sorry, I was a little late. I am the supervisor of Workers Rehabilitation Services for a small agency. Our mission is to get injured workers in Connecticut back to physically appropriate employment. I have a I'm going to share my screen with you. I have a abbreviated PowerPoint presentation. I'm just going to show you. That'll give you some of the information I think that would be of interest. So let me share my screen. I do it in Teams all the time. I'm not super. Share screen. Here we go. Oh. Share entire screen. Okay, I don't know if you can see my screen or not. Doesn't seem to be a live link for me. Can everyone see my screen or no?
No.
No.
We
Not
may
yet.
have to give you permission, so stand by just a second while we sort that out.
Okay, great.
So
Thank you. I think it'd be helpful.
Yep, I did make you co-host, so you should be able to hit that green button at the bottom, at the ribbon at the bottom of your screen that says share screen, and then you'll just select either the entire screen or the PowerPoint or whatever you'd like to put up on the screen there.
Okay. All right. I have it. I have choose what to share with Zoom. I have entire screen, but I cannot click on it. So I'm not
Once you highlight
sure.
that box in the bottom right of the dialog box, it'll say share.
I did see that. I did do that. Yes. But it's not allowing me to do that for some reason. Okay, let me do a share screen. I see that. It says clicked on it. Yep, and I see a thing that says a prompt that says entire screen, but I cannot click on it. I'm not sure why it won't. It's not alive for me. So I can just go through this. Verbally with everyone. I think it would be helpful for people to see it, but
Is it giving you any other options besides the?
it says mic. No, it's just a share audio system. An entire screen is on the far right. It's in blue. There's a share button on the bottom, but it's not highlighted, so I can't. I can't.
So if you click on, can you try to click on the entire screen or whatever option you'd like again and see if that, there you.
Okay.
Nathan
I see
is
somebody's
sharing.
screen, but it's not mine.
That's Nathan's.
Yeah. I think someone does have to give me permission to do this.
You should have permission if you're able to open the share screen window. Then that means that you already have permission to do it.
Well, all right. It's not letting me. Sorry about this, folks.
Let me see if I can reach out to our IT person really quickly. See if she has any other solutions.
Yes, I can do that.
Yeah, do you want to email it to me?
Sure, that'd be great. Can you hear me?
We can now.
Yep.
Okay, I'm going to try it again. Entire screen. No, I can't. Krista, did you give me your email address?
Yeah, I put it in the chat. I don't know
Okay.
if you saw that or not.
I'm not seeing it.
So I can just give it to you. So my email address is Kirsten, KIRSTIN .Breiner, BREINER @cga.ct.gov.
Okay. Okay. Should be getting it soon.
Okay. Thank you.
Yeah. I think One of the things I want to talk about is our work. So the committee has a really good understanding of how we meet with our focus again is to return the injured worker to physically appropriate work within their permanent restrictions. And there's a process that we go through to determine that with the treating physician and the client. And then we do a lot of vocational counseling and identify resources. We do a lot of retraining and have some other services that help clients do that. And that's what I want to review with the community today. Kirsten, I'm sorry, did you receive the
I didn't get it
email?
yet. I just maybe if you just double check that my name was spelled right.
Okay, I'm gonna try it again. I don't want to spend too much time. Okay.
Kirstin
Yep.
and
Thank you.
Brei.
There you go. Yeah, it just won't let me do it.
You just start walking us through it, Karen. While you're
Sure, I'm going to do that. So one of the things I'd like to talk about briefly is who can make a referral to workers' rehabilitation services, and really anyone can make a referral. An individual who has a workers' compensation claim, an injured worker can refer the chairman, judges, attorneys. We get referrals from insurance companies, medical providers, rehabilitation nurses, rehabilitation centers, physical therapists, employers can refer, Department of Labor, a friend, really anyone can refer to our program. We do have a presence online. The application for our program is there and available to folks. The services that we offer range from vocational counseling. We do vocational evaluations. We do aptitude testing, which identifies a person's strengths in learning, and it includes interest testing, which matches them up with their strengths and their interests in different types of jobs that are available here in Connecticut. We do a lot of formal training. We utilize the community college system, which they have a lot of certificate programs, and we will pay for up to 60 credits for a 4-year program, and we will pay for an associate's degree. And all of our services are paid for through state funding, through the Workers' Rehabilitation Services funding on behalf of the clients. We do on-the-job training with employers. We haven't done a lot of that in recent past, but there was a time when we did do quite a bit. That's partnering with employers, identifying a skill set that a worker needs, upskilling essentially, and we will pay the employer to train that particular individual to gain the skills they need, either to retain employment or it could be with a different employer as well. And we also do, which is really an integral part of our services, a job skill seeking training, and we do job placement services as well. So we help people after we've worked with them, after they've received training. We work with the schools or the placement career centers at the schools to help our clients find jobs, but we also utilize a vendor who's like a recruiter who works with our clients and places them in jobs in Connecticut. Our intake process, when we first meet with a client, we call it an initial interview. We collect relevant information about their injury, the nature of the work that they did. We obtain work history to look at transferable skills in the event that they are not going back to their jobs. They won't be able to fully recover to do that. We
Sorry
gather
to
the
interrupt you,
educational
Karen.
background. Yes.
Can you see this
Uh-huh.
okay? Okay. So I don't know, just let me know.
Oh, super. Okay. We can go on to the next screen. I think yeah. Again, this week I can make this available to everyone if they would like. The service is available, and I'm on the next screen. We're talking about intake. There you go. So we gather the educational background. Do they have a high school diploma? Do they have a GED, or do they have some college under their belt? We talk about, explore what the client's thoughts are around their future with regards to work. A lot of them really have no idea, and we help them through that process. Once we find them eligible for services, again, we do a lot of what we call vocational exploration with our clients. But some of them have an idea right out of the gate what it is they would like to do. So it really is really runs the gamut. We do the necessary assessments, as I said, vocational evaluations. We do the interest inventory and the aptitude testing. And then we have to document a client's eligibility for our services, and that will be the next slide. It's pretty straightforward. We have to have a documented compensable injury. We have to have permanent restrictions from the treating provider. We have to have a record of no light duty work available from the employer, and they have to be a U.S. citizen or have permanent resident status or a work permit. And when we talk about no light duty work available, that means that they could still technically be employed with the employer, and they haven't formally severed their employment there. But the employer has told us, I don't have permanent light duty work available for this individual. And the permanent restrictions we typically get from as I said, from the treating provider. Okay, the next slide, please. Again, some of the discussions that we hear, we call them myth busters, questions that we get asked about our process and our program. Again, you have to be terminated by your employer before you apply. We just need to know that there's no permanent light duty work available for the injured worker. Workers Rehab Services is not a mandatory program. Some clients may think that, and they think it might negatively impact their adjudication of their claim, but that's not the case. You have to a client has to be at MMI before they apply for our services. They just have to have permanent restrictions from a doctor. For example, the person is an iron worker and has had several back fusions or had a significant back injury right out of the gate, that we know that they're not going to be going back to the kind of work they did. They're not going to be an iron worker any longer, and the doctor can give us, based on that, can give us the permanent restrictions that they think the client will have. A judge determines eligibility for workers' rehabilitation services. Our rehabilitation coordinators are the ones who determine eligibility for the program. There are times when a claimant settles their case, they've been told you're eligible for this program, either by an attorney, typically by an attorney. And sometimes that's what the client hears. I get all this retraining, I'm eligible for the program. We just have to clarify that when we first meet with the clients, that that's not the case. Workers Rehab Services, strictly a training program. Our vocational program, as you saw in an earlier slide, we offer a lot of other services. We do a lot of retraining, but sometimes a client doesn't need retraining necessarily. We're tasked to get injured workers back to work as efficiently, as effectively as possible. So, for example, you might have a nurse who can't perform the physical demands of the nursing occupation, but they might be able to work as a medical assistant, for example, or a medical billing encoder, which they may need some retraining for that. That's a very specific. There's specific criteria for that particular occupation, but they might be able to return as go back to work as a medical receptionist or a medical assistant or something like that. That's where we utilize transferable skills to look at other occupations that will utilize their already acquired work skills. You must have a high school diploma in order to be to work with us. We work with people who do not have high school diplomas in a number of different ways. In fact, the community colleges right now do have certificate programs where a high school diploma is not required. We also can do direct job placement with those particular individuals. Again, that really all depends on what their permanent restrictions are and the nature of the work they did at the time that they were injured. You cannot apply to workers' rehab services if you are on Social Security disability. Again, that's not the case. We don't see a lot of individuals who are on SSDI, but we do see some who've probably applied at the beginning of their injury and were approved right away. But Social Security disability does have a work incentive program, and so anything we would do with them in terms of helping them get back to work would complement the Social Security disability work incentive program. So
Just let
these
me
are
interrupt for 1 second, because I think there's one box you missed. On, do you have to be able to?
Oh,
To
yes.
speak English in order to use Voc Rehab services?
Yes, thank you very much. No, you do not. We take a really close look at that with our claimants. Oftentimes, they're working in communities and for employers, for example, who are primarily Spanish speaking. We see a lot of that. Typically, in the workplace, there are supervisors who are bilingual. This aspect impacts a person's ability to train in terms of going back to going into a formal training program. Is many of those training programs, as you know, are taught in English, and a person has to be able to read and write English. We can offer job placement services for someone who's a non-English speaker. We can also work with some of the resources in their local communities to help them, for example, get into an English as a second language program. So, yeah, that's definitely. We also have translator services as well. So we do utilize translator services for people who can't bring a translator, for example, to a meeting, that sort of thing. So does that answer the question?
Yes, thank you.
Yeah, thank you. Lastly, frequently asked questions. We do not have jobs or a job bank like the Department of Labor does, for example. All of our training and all of our work with our clients is highly individualized. In the end, we identify a vocational goal, which is a job goal that we've determined to be available to that person in their local economy, and we've determined what kind of services they need in order to access that goal or that job, whether it is retraining or job placement services. This is not an entitlement program, so clients are not entitled to this particular service. To rehabilitation services, as I said, we have to find them eligible through our eligibility process. And again, our training is highly, very, very individualized. I've worked with, I sent someone to school to be a recording engineer, sound engineer. I worked with a former police officer who's went to Western and got his degree in finances and now is working for a financial company. We've also, down to train people in the area of CAD, computer-aided drafting and design, medical billing and coding, medical assisting. So the really the sky is the limit as far as what a client can be trained for. Our focus is on getting people into jobs that are physically appropriate for them in view of their permanent restrictions. We do try to look at industries and help people get back into the job market at a level typically that is close to what they were earning at the time they were injured. This is at the outset. This is or at the entry level aspect of returning back to work. This is not a guarantee. It is something that an individual can grow with a particular company and earn better wages as they spend more time working in the company. But we can't guarantee that they can make the same kind of money that they were making when they were injured. And it's really, people are oftentimes starting all over again, brand new in careers. But there is a career ladder for them, because we're not looking just to put people into jobs. We're looking to put people into careers because they've left and have been injured at a former career, and we'd like to help them. Our focus is to help them gain skills to access new careers. There is no time limit for our services. Some individuals come to us and they start the process, and then something happens. They have a surgery, and they need to recover from that surgery. As long as an individual still remains eligible for our program based on the permanent restrictions that a doctor gives them, they will continue to be eligible to receive vocational rehabilitation services through our program. So there is no time limit on their ability to access our services. And I think this is just an example of what our application looks like. It's very simple. It's on a trifold. It's one piece of a trifold, or it's one sheet of paper. It's very, very simple for them to fill out. They do need to sign it and get it back to us. And from the time that we get the application, it takes about 2 weeks to get them into our system, and for the rehabilitation coordinator to reach out to them to schedule an appointment. It shouldn't take any longer than that. So that is sort of in a nutshell what the vocational rehabilitation program through Workers Rehab Services is all about. Some people have varying levels of experience with our program, and I presented part of this PowerPoint presentation at a conference in 2021 to the Connecticut Bar Association annual conference in Hartford. So I'd be happy to answer any questions or any discussion about our services.
What percentage of injured workers with accepted cases avail themselves of your services?
I don't know the percentage. I mean, I can tell you how many applications we've gotten in, and we can and that sort of thing. But in terms of how many people have injuries and how many people take advantage of our services, I really wouldn't know that information. I just don't have access to it. But last year, fiscal year 2022 to 2023, we had 640 applications that we received, and we had 273 injured workers returned back to the workforce as a result of that. And at any point in time, we have between the I have 4 rehabilitation coordinators we have, and they have an average caseload between 120 and 150 clients. So they maintain that on average throughout the course of any given year.
Okay, thank you. Representative Acker.
Thank you, Representative, and Karen, thank you.
welcome.
Quick question, I see under the heading of Aging and Disability Services, it
Yeah.
looked like on your screen there on the form. How are you funded again? Is it a federally funded, state funded, or is it through Workman's Comp?
It is through workers' comp.
Okay.
It's funding that comes through the the monies that go into the workers' compensation system, that companies pay, right? Excuse me.
So
Through their assessments.
okay, so your department gets a block, essentially a block. On
Yes.
that, okay. Good. Thank you.
Yeah. You're welcome.
Marie?
Karen, I think I heard you mention that a claimant does not need to be at maximum medical improvement before they apply to services. I know there was some discussion last time we met. There were some concerns raised about individuals running out of indemnity benefits before they finish your program.
Mhm.
So could you just talk to us about that a little bit?
Sure. The sooner that we're able to see an injured worker, or we call them clients, the sooner we're able to see a client, the sooner we're able to work with them and get them into services and help them get back to work. Typically, we see them when they've settled their case, when they stipulated their case, or when they're at maximum medical improvement, but we can see them when they have temporary total or PPD. We can see them as really as early on as TTD, probably. As long as we can get permanent restrictions from the doctor, which we will write for the doctor to ask very specific questions about a client's physical functioning. The doctor will respond to us saying, these are what their permanent restrictions are. Sign off on the document, and then we can work with them. Our training programs typically last from 10 months to 2 years. And I'm sorry to say, but when by the time we have our clients into services, their benefits probably have ended. And our clients will say, well, I need to do something now. My benefit is ended, and I need to get back to work. We, as often as we could say it to judges and to attorneys, the sooner we see a client, the sooner we can get our hands on a referral and start working with a client, the sooner we can get them back to work. Now, clients, can work, and some of them do. I don't want to complicate the issue here at all, but they can work and go to school and go through training, at the same time. However, that's a whole that requires some investigation on our part. Are they doing physically appropriate work? And if they can return to work earning more than 10% of what they were earning at the time that they were injured, then they wouldn't be eligible for our program either if they are working. But that's we don't see a lot of individuals working and trying to go back to school. Typically, they have other supports in their lives. Go ahead. I'm sorry.
Yeah. Do you know if you've had anyone drop out of the program because doing the program was preventing them from earning money?
Oh, yes. I'm sure that has happened.
Okay.
Yes.
All right. Thank you. Nate.
Can you hear me now?
Yes.
Okay, good. Thank you so much for speaking with us. So,
oh, you're welcome.
Applying earlier is better, even if
absolutely,
even if they're still on total disability. Maybe they can't. You can't start with them, but at least they can meet with the representative and start moving forward. That would be okay as well?
Yes, yes, absolutely. And I mean, think about it. At that point in time, if they are, if it looks like, again, if they're an iron worker, if they're a construction worker, if they're a nurse and they're having had a significant work injury, and the judge knows, the doctor knows, we know they're not going to be able to go back to the kind of work that they did when they were injured. We just know that,
Okay.
right? Because of our expertise and what we understand, what we understand about the nature of work, then we can start working with them. I'm not sure that we would be able to get permanent restrictions when they were in temporary total. However, it may happen. And in that case, we could find them eligible. But typically, we get permanent restrictions when somebody's at PPD right now or at MMI. We don't even see a lot of folks at temporary total, I don't think, at this point in time.
It's
But we
often the case. It's often the case that when people are given, they've moved from total disability to temporary partial, that those restrictions ultimately turn into permanent restrictions.
Yes.
And ideally, if the process could start at an earlier time, then perhaps they could start the retraining while in temporary partial before they reached MMI.
Yes.
Would give, perhaps another 4 to 6 or 7 months more of being in the retraining program or
Yes.
schooling while still receiving benefits. And
yes, absolutely.
okay.
I don't know why we don't see those referrals earlier on. I really don't. Any suggestions for outreach that we could possibly do to educate folks on that topic? But yeah, I agree with you 100%, Nate.
Thank
I
you.
mean, we would love to see them at temporary
The other
partial.
thing, you have to have a compensable claim.
Yes.
And that's documented by the voluntary agreement. Is that what you're looking for, to confirm that it's a compensable claim?
Yes, the voluntary agreement, at early on, that would have to be in place. Now, I will tell you that there are instances where we can't get a voluntary agreement for whatever reason. We will write the insurance company, and we'll write them up to 3 times on behalf of the claimant to ask if this is a compensable injury. And we have a process and a letter with which we do that. And the insurance company will respond to us, yes, it is compensable, or no, it's not.
Okay.
And that can happen before we even see a voluntary agreement. We've also had, not on very few occasions, we've had a letter from a judge that has let us know it's a compensable injury.
2 more questions. If they've completed a undergraduate program, but they're wanting to do something on a graduate program, would you provide funding for that?
That's a very good question, and it really depends. It depends if they have whatever their permanent restrictions are, and if they have the skills to be able to return to work in a physically appropriate job with their undergraduate degree, we will help them do that. We would not pay for a master's degree. If we determine that a master's degree is needed to get them physically appropriate work, then we would consider doing that.
Okay.
It's very, very, very rare. I mean, I've only been here 7 years, and I can't think of anyone we've sent for a master's program at this point in time.
Well, last question, Karen, and I know I'm taking up a lot
Sure.
of time. What injuries do you find are the worst in terms of being able to place people? Are they the backs? Are they the hands, the arms? What do you, if you have that? Sort of out of
Yeah,
that
that's
a
a
left
good
field
question.
question.
Yeah, no. It's really, to better answer that question, I'd have to talk about the nature of work. It really depends on what their what they were doing for work at the time that they were injured, and how their permanent physical restrictions impact their ability to do other forms of work. I mean, if you have a person who was a medical billing encoder and could no longer use her hands for repetitive typing, right? And we think of, oh, well, we use our hands for so many things, right? However, depending on what the doctor says about, when we drill down to this fine detail and we get permanent restrictions, what the doctor says about her ability to do repetitive fine motor grasping, fine motor skill activity versus gross, which is more grasping and gripping, they might be able to work as a medical assistant, for example. Right. So to answer, I'd have to answer your question that way.
Okay.
It's the most difficult individuals are the people who who don't have a high school diploma, who are very limited in their English speaking skills, and you have what we call sedentary workability. They can't lift anything more than 10 pounds, and they have to either alternate position or be seated most of the time. I mean, that's sort of a desk job that typically requires retraining. However, there are some manufacturing jobs that you could learn on the job that would provide seated bench assembly work, for example. So we will look at that for that person before we say, we wouldn't be able to help this person at all.
You mentioned before, and I do recall this years ago, there was a big outreach by, I think it was called Division of Workers Rehab at the time, where employers were, there was some sort of courtship between the employer and the organization for looking for people. And why is that not continuing the way it used to be, or is there no longer interest on the part of the employer? Is it just difference of communication? If you have an understanding of it.
I have a little bit of an understanding of that. I know how the process works, and in another lifetime, I did on-the-job training programs. That's what we're talking about with another rehabilitation agency, the Bureau of Rehabilitation Services here in Connecticut. For workers' rehab services, my understanding is they had the funding to fund a position that strictly developed those kinds of working relationships you're talking about with employers. They went out, they met with the business community, and they developed what we call on-the-job training programs with employers. And that was a person who was specifically designated to do that. Tony D'Agostino was his name. And that position, for some reason, I'm not sure the history of it, did go away. I'm not sure if it was when Workers Rehab Services was disbanded under the Rowland administration, and then when it restarted with less funding, and that position was eliminated. That's my best guess. I'm not sure completely, but we don't have that particular position now. The counselors, because it is a service that we offer, several counselors have on their own tried to, we'll talk to employers and we'll talk to our clients about the on-the-job training opportunities, but it really needs a dedicated person to have that conversation with employers and to get out there and, knock on doors and hit the streets, and develop that relationship again. I hope that answers part of your question. Anyway.
I think you did. Thank you for answering my
welcome.
questions. Thank you, Karen.
Oh, you're very welcome.
Thanks. Bud?
Yes, I'd like to join everyone in thanking you for your presentation and also for the work you folks do. You really, those are what the success stories, the rare success stories that we see do come out of your department, where you give hope and a plan to people who have lost their chosen profession. And it really makes a huge difference. I have three kind of unrelated questions. One is, the first one is, what is the appeal process, if there is one?
Thank you for that comment. I will be sure to let my staff know. I'll pass that information on to them. Thank you. The appeal process, if a client, excuse me, is not if a training program is not approved for a variety of reasons, not physically appropriate, the jobs don't exist in the local economy, the training is not available. We only utilize state schools. We don't utilize out-of-state schools. There's a number of reasons why a vocational plan which commits the funding for the program is not approved. They have 15 days to submit an appeal to myself, the supervisor. I'm sorry. I'm not sure if they have 15 days. I have 15 days to respond to them, to their appeal. If they are not satisfied with my response, then it would go to the chairman, I believe, to further evaluate.
My second question is, what is your current level of staffing? So I know you service all 8 districts, correct?
Yes, we do. For the past year, we've been without a rehabilitation coordinator. I was promoted to supervisor. So I have been sort of wearing those 2 hats to the best of my ability. We have, when we're fully staffed, we'll have 4 rehabilitation coordinators, a supervisor, and an administrative person. Currently, we have 3 rehabilitation coordinators. We're very close to hiring a 4th. So we
And
should be fully staffed shortly.
You meet the injured worker in the district that's most convenient for them, correct? Not necessarily in the district where their case is.
Correct. We meet the injured worker there where they live. The district office closest to where they live. That's how we base our case assignments. Yes.
And my final question is really just by way of clarification. There is no stipend or any program where the injured worker can receive a stipend during retraining. Is that correct?
Yeah. There was in the past, but currently there is not. And I do not know why that stopped, quite frankly. But no, there's not a stipend currently available.
Do you know when there was a stipend, what was it?
I'd have to get that information and get back to you, sir. I'm not that familiar with that part of our program. It's been gone for such a long time. But I can find out and I can get that information to you as far as how that was operationalized and how it was
I
run.
think that would be helpful. I mean, one of the things that we're considering is a possible expansion of post-specific 308A benefits. And certainly if there was an ability for an injured worker who was enrolled in voc rehab to avail themselves either of that or reestablishing a stipend program, that would probably be of some benefit. Rep. Conley?
Understood.
Thank you. Thank you for the presentation, Karen. Now,
You're welcome.
my question has to do with the meat and potatoes on how do we get a person in there. Less people are using mail now, and I know that the application is still to be mailed in. Has your office looked into an online and email, some sort of way to get those applications or that information to you quicker so that you can provide the services to the workers quicker?
Excellent question. Thank you. Applications can come to us via email. They do come to us through the mail. People can email them to us. Again, they're available online. I can get you that link. Even what happens though when somebody fills out an application after a STIP hearing, for example, or after a hearing, they've come into our office. What we'll do is we will scan that. We'll take that application, scan it into our system, and then just email it to our central office so it gets there it gets there the same day the application is dropped off. Now, keep in mind, counselors are in their offices 2 days a week to pick up those applications and to meet clients.
I just learned that they could be emailed. Is there a way that that information can be updated on the form? Because the address,
Sure.
I just looked online, the mail address is the only thing on the form.
Okay. And that's the online application you were looking at?
Correct, yes.
Okay. Okay. Sure. Absolutely.
And if someone is, let's say, not physically able to get to an office, like if they had car issues or transportation issues, is there a way where they can meet electronically by Zoom or by phone to get that process started?
Oh, that's an excellent question. We do meet with our clients via Teams, Microsoft Teams. That's the application we use. And we do some of our testing actually via Teams. So that's how we would meet with them. And we go through the process of setting them up with the application on their phones or on their computers. So we talk them through that whole process. But yes, we do meet with clients via Teams.
So I might be thinking about the pre-COVID days when the clients all came to the comp offices.
I know.
And then my last question had to do with, I know sometimes we'll hear from folks that they need records and your office will send them the letters that they need records. Is there anything that you think from your office standpoint that the bar can do to speed the process along to get folks in?
That the bar as an organization can do
The
to help
members
us?
of the bar. Like, is
The
there a
members?
frequently asked documents that somehow could be posted or disseminated? So if we know someone applied, what they're going to need, because I think I kind of get to see the same letter from your office on a regular basis.
We could definitely put something like that together. And the initial, what we call the initial interview letter, once we made an appointment with a client, they receive an initial interview letter that gives them the date and the location of the meeting and all that. It does spell out the documents that are needed. Now, look, what we tell clients is if they don't have all of that information, we will help them get it. But I can send, would I send that fact document to you, Representative Conley, or we could certainly put something together that talks about, what we need for documents we need for eligibility.
And then I got a question, because I think the stipend is before my time, because I think it got canceled that long ago.
It did, yeah.
When you look into the stipend, could you also look into if childcare was an option, or if it was just a straight stipend? Because I know Rhode Island does have a mileage childcare component, and I think that could be helpful.
Sure. I will do that. I don't think it was part of our practices in the past, but I can definitely look into that. And if you're saying Rhode Island has a model for that, I can look into that as well.
Thanks, Karen.
Thank you.
Marie?
Yeah, my question actually has to do with the stipend too, Karen, because it was a long time ago that I believe that the stipend went away. And I'm relatively new to the position that I'm in. I've only been here for 2.5 years. So, Mike, when you're looking into the stipend, if you could also find out how that stipend was funded. Was that part of the Workers' Comp Commission funding to DWR, or did that funding come from another source?
Okay, I will do that.
Thank you.
I do believe it came out of our budget though, but I will look into that further. The Workers' Rehab Services budget.
Any other questions or comments for Karen specifically, or the vocational rehabilitation process generally? All right. Well, thank you very much, Karen, for joining us today. We greatly appreciate it and look forward to hearing back from you And you let us know whether it's simpler to just provide the answers and we can disseminate them to the committee members, or if you want to come back and do another presentation on
Thank you.
that.
Thank you very much.
Good.
Thank you for the opportunity to meet with you all. I really appreciate it.
You're very welcome. And I know you had faxed the PowerPoint, or excuse me, emailed the PowerPoint to Kirsten. Will either her or Nate will get it out to the committee, so we'll take care of that.
Okay, thank you very much. Thank you.
You're welcome.
All right. Well, happy holidays to everyone. They're coming up, and I look forward to getting the information to the group and hearing back.
Okay. Thank you.
Bye-bye now.
All right, next item on our list is a discussion regarding the current benefit limits. And really, this was the impetus for me, and what started this whole thing is that, as we know, currently, the number of weeks that you can receive for 308A benefits is capped at the number of weeks of your permanency rating. Prior to the cap being put in, you had an unlimited entitlement to them. I think that the cap should be expanded. I don't think it should be eliminated, but I wanted to open it up to have to start a discussion on where we should be looking for that, understanding that we have committee members coming at this from entirely different angles, and actually that's what we wanted when we formed this committee, so that we could hopefully come to some sort of a consensus as to what direction to go in expanding these benefits. Representative Acker.
Thank you, Michael. Appreciate it. So not playing in this field that all of you knowledgeable folks do, is there a standard, national standard that is on these benefits, or is it a state by state kind of a benefit plan?
I would gather that it's state by state, and not practicing in other states. I'm not entirely sure if anybody does it the way that Connecticut used to do it, or if there are versions out there that are incredibly different. And I'll defer to some of my colleagues. Nate?
Thank you.
Yeah, there are, each state has its own Workers' Compensation Act, and they vary on it. Some states have caps. Some states don't have caps, but they do things differently, such as with a permanent partial disability. We have ours limited to a specific number of weeks in the statute. Other states look at when you have a permanent injury, they assess a value to it in terms of a loss of earning capacity, and those can go on in some cases indefinitely, as long as that limitation or that loss of earning capacity exists. So they vary as wide as the spectrum can be on that. Hopefully I answered your question.
Yeah, so it's kind of a wild west, I guess, right? Depending on it, in a way, each state has created its own structure. So depending on it, and I didn't know, that was very helpful to me.
Any other thoughts or comments to kick off the discussion on this? I mean, obviously, if any expansion of benefits that we do is going to come with a cost, and that cost is going to be borne by insurance carriers or self-administered employers. You know, what I've seen in my practice is, and it's particularly with less educated workers who have done manual labor jobs and get that physical injury that is going to be with them forever. and really prevents them from going back to that original type of work. And, you know, the vocational rehabilitation training is very helpful, but it isn't a guarantee that someone will be able to return to their pre-injury income levels. And while I agree that there probably should be there should be some sort of cap, I think that it's, as it's presently configured, I think it's too restrictive. And I've had a number of clients that haven't been able to find gainful employment after their 308A benefits run out. And this is even true in the cases of people who have availed themselves of the vocational rehabilitation training program, fully understanding that I have a lot of clients that haven't availed themselves of that. So that's where I'm coming from on this. And I'm interested to hear everyone else's thoughts and concerns. Nate, is your hand up for this, or was it up from before?
It is, but I think Miss Foley was first.
Okay, go ahead, Brooke.
Hi, good afternoon. I'm curious, like, what is the basis for looking at whether or not Connecticut's rates are insufficient? Because I think it's important to compare what we have with surrounding states and with, you know, other states and what they do in terms of workers' comp generally and PPD, because I've been looking at what, you know, where Connecticut falls compared to other states with just max weekly payment amounts and with the base rate. And it seems like Connecticut has very generous benefits in terms of workers' comp in general. And so I'm just wondering, you know, what is the argument for the need that it needs, you know, that it needs to be increased? I'm just not seeing that. And I think that was one of the initial considerations that we as a group were supposed to make as far as the work, you know, in this working group. So I'd like to talk about that or hear from you about that.
Okay. Nate?
Yeah, I can respond to Brooke's point. Connecticut's probably, in terms of the comp rate, it's probably on the higher side amongst the states. But where Connecticut falls short is by putting these artificial limitations on benefits once you reach maximum medical improvement. And that because prior to maximum medical improvement, you have total disability, which theoretically could go on forever. You have temporary partial benefits, which the commissioners have discretion to award up to 520 weeks. But then once you hit this maximum medical improvement, you cross that bridge, you hit this artificial barrier where it all of a sudden falls to a specific number of weeks. And then when you tie the 308A component, which is the commissioner's discretion, to those number of weeks of the specific, what you end up with is, as I said, these artificial barriers. And so what happens in Connecticut is you treat every injured worker not as the same. So, but one person's 10% to the hand may not prohibit them from going back to their job or even getting another job. But another person's 10% to the hand, as Karen pointed out, you know, could possibly impact their ability to go back to their job or even find placement. So I think Connecticut has to start thinking that each body part, we have to stop thinking of the claimants as body parts. We have to start thinking of them as specific persons. And if our workers' comp act can be tailored to that a little bit better, then we can provide for what's currently these unprovided situations. And you know, I gave the example of the hand, but you can see the same thing with someone with a back. Clearly, a construction worker who's had a double level fusion may have a difficulty going back to their regular job. That may not be the same necessarily as someone who got injured with a sedentary job. So I think we have to find a way to fashion the remedy that allows our judges who get appointed to be able to discern that difference, and so they can award those appropriate benefits in the appropriate cases.
Thank you.
I'm not sure to answer Brooke's question, but that's kind of Massachusetts does things a lot different. Massachusetts has open medicals, and they have longer periods of time. They have shorter rating periods, but they seem to have a longer period of time where someone could be either on total disability or temporary partial, and it seems to provide a better relief for injured workers in Massachusetts. Chris, do you know a little bit about Rhode Island? No, even though we're joining it, we can certainly get that information. That's easy enough to gather.
Chris?
Thanks, Roseland. Where my thoughts were, and I'll use the words of one of our fellow representatives who's not on this committee, but wanted her thoughts to be shared. Rep. Johnson talks a lot about the workers' comp to social services pipeline, and workers' comp to Social Security disability, workers' comp to Medicaid, and the issues of broader economy, that this isn't just about a PPD rating. This is, and what my goal in this is to deal with the overall problems as to what happens when an injured worker can't return to their full job, and how we as a state, how we as a society are setting these arbitrary factors around reemployment. And if our arbitrary factors are sufficient, and in my mind, they're not sufficient, because again, we on this Zoom call, we're all sedentary desk workers. We can have substantial physical impairments due to a work injury and be able to sit on a Zoom call. Maybe we'll need a standing desk. Maybe we'll need to sit and stand. But we can sit on a Zoom call and do our jobs all day, every day. Some of us do that. Some of us do that more often than we'd like. But we could have that same injury and be a roofer, be a welder, be a physical laborer, and that person with that same contractor, my good friend Tim, that person with that same injury is put out of the workforce. And me as a desk job, and that worker gets the same amount of weeks of benefits. Now me, I can probably do my job with a pretty substantial injury as a desk worker, but that same worker would need voc rehab, would need a retraining. And to talk about where our benefits are lapsing in the workers' comp world that we can work on, that can get that person back to work, can get that person back to mental abilities of working and providing for their family, and not utilizing our social services if it's not necessary. So that's kind of why we decided to have the presentation today about voc rehab, to teach that and to learn that and to disseminate that information better. And hopefully we can then address the benefit scheme as to what's needed for funding, what's needed for appropriate benefits, so that that person is not, because they had a physical injury at work, is not left out in the cold, left out with no work, left out with no services, and getting, something like a 10% to the neck, getting 11.7 weeks of permanency, 11.7 weeks of 308A, and in 23 weeks being told, so sorry, no more benefits, good luck with the next 40 years of your life. Because we want that person to be a successful member of our state, a successful Connecticut resident, and to avail themselves of all of our services, including voc rehab, including our other services that the state can provide. So I'm hoping that's where our discussion goes, is where can we make the benefits better? Where are they lacking? Where are they sufficient? And how can we fund the lacking benefits?
Thank you. Bud?
Yeah, I certainly echo the comments by Representative Conley. And, just to give us the proper perspective here, the cases we are talking about are serious cases where someone has a permanent injury, permanent work restrictions that prevent them for forever returning to their prior job, and their employer has told them they cannot accommodate those restrictions. And so now we have a person who is out of work, and needs a way to pay their bills. And obviously the goal should be to get them back into the workforce. But in the meantime, they need to pay their bills. So that's the situation we're dealing with. And as Representative Conley says, you know, who's going to pay for that? You know, who shoulders the burden of that cost? Is it going to be the comp system, you know, the comp carrier or the municipalities? Or is it going to be the other social programs that the state has? And so, again, once you start removing discretion from the ALJs, which was done in '93, and start making hardline rules, you're necessarily going to create injustices for serious cases. That's just the way it's going to be. So I think we do need to put some more discretion in the hands of the ALJs to deal with these more serious cases. Now, whether we continue to tie the cap to the permanency benefits, or whether we deal with it in some other way, I'm not sure what's the best way to proceed. But I just want to remind everyone, these are the cases we're talking about. The serious injuries, someone's lost their profession. What do we do now?
Thank you. Anyone else have any general comments either on the voc rehab process or the 308A benefit limits? Yeah, go ahead, Tim.
Yeah, and I don't know how this works out, but you know, I look at it as Chris was mentioning, people that work at a desk. My life is, you know, on a ladder, working with, you know, electricity, things like that, where I deal with construction workers on a daily basis. And what always comes to my thought that if a worker violates the safety protocols or the proper equipment use, let's say your training is on the top step of a ladder per se, right? Training is you can't step on the top ladder. This is right on the ladder. You can't. Your training is that they're standing on the top step of the ladder. They fall and get a disability, as Bud was, you know, commenting on, severely out of work. You're done. You can't do that work anymore. Workman's comp doesn't really have any decision on what, you know, if they get benefits or not benefits to what level, right? It's just, you got hurt at work, even though you were violating your company's protocols, you still get the benefits, correct?
Yes. Yeah, because it is a no-fault system.
Yeah, that's what, yeah, even though it's clearly you did something wrong on the job site that you weren't paying attention. So I was just curious on that aspect of it. And then how we, you know, as Brooke was mentioning, you know, in our cases, we've been working diligently in the state of Connecticut and done a very good job to lower the workman's comp rates that we can be competitive with our surrounding states for bidding on larger projects in the state of Connecticut. It's really been helpful. Thank you for your responses to that question.
Marie?
I just wanted to respond to Tim's question. Just as a little history, as Mike said, it's a no-fault statute. If you go back and look at the legislative history back in 1913, there was a lot of discussion about this no-fault policy. It was hoped to limit litigation by allowing employees to get paid without having to hire attorneys and to go through years of litigation. Now, the system has gotten more complicated over the past 110 years, but it's supposed to be worker friendly. It's not supposed to be a situation where the big employer can just sort of wait it out because nobody's getting benefits. And so, you know, your employees are going to have to cave because they can't afford to go through the system. So that's sort of why there's a workers' comp no fault. There is a section of the statute though that deals with certain situations, like if you're drunk on the job and your inebriation has caused the injury, willful and intentional misconduct. That's a hard burden to prove, but there is that out there.
Thank you. Anyone else on this?
Like
Okay.
I'm sorry, if I could just say something real quick, Joe.
Yeah, go right ahead, Joe.
I think for those, some of the people in this group do have the perspective of what Public Act 93-228 was issued for. That's the thing that we call in our world reform. And workers' compensation reform in 1993 happened because we were experiencing economic downturn, economic turmoil, companies quite literally packing up and leaving. The benefits were reduced at that time in response, and economic prosperity resulted. I think that it's necessary in a group like this, in as much as there is altruistic and benevolent feelings on behalf of the injured worker, we have to also be mindful of the fact that they need some place to go to work. And not trying to be doom and gloom about it, but we have to balance the opening up this idea of discretion to the ALJs, countered with the fact that we want business and industry who have chosen to their detriment to do business in Connecticut. We want them to stay. I think it needs to be said.
No, thank you, and I appreciate that. What probably would be instructive for our next meeting is that there's 3 directions that we can go in. Direction 1 would be not to change a thing. Direction 2 would be to go back to pre-1993 and have an unlimited entitlement. And then option 3 is everything else in between. And I think that most people have been an option 1 or an option 3. And I haven't heard anybody say we ought to go back to the way it was prior to 93. But what if possible, why don't you each jot down your thoughts and what proposal that you would like to see go, and we can have a discussion on that for our next meeting, if that makes any sense to everyone. All right.
Sorry, Mike.
Yeah, go ahead.
I just want to reiterate that I'm not going to send you any thoughts on where we should go, because that's not my place in this working group.
Yeah, that's fine. I won't hold it against you. Nate?
Yeah, as you know, Bud and I submitted a proposal, and so that would be, I suppose, our position on it.
Okay, and that's fair enough.
But what I was going to suggest, and maybe you might have otherwise, or other people certainly have other ideas, but certainly the thought behind that proposal took into account, we were there prior to 93, we were there during 93, we were there after. We've handled all these cases, and the proposals that we submitted is really an amalgamation of ideas, thoughts. Some were taken from pre-93, others were taken afterwards, but it was, the thought was to address the inadequacies of the compact now without jumping back into what everything existed prior to 93, because it's a different world now than it was then. So one thing you may want to consider is just, I don't, certainly other people can submit their proposals, but what I'm suggesting is that we just use that as a sort of a starting point or a jumping point with what we submitted, and if that could be shared with everyone before our next meeting, I think that would be helpful, because at least you see where Bud and I are coming from on this.
Okay. Yeah, we'll do that right away, so that everyone has an opportunity to look at it and digest it and present other ideas on it. Go ahead, Bud.
Yeah, and also, if we could maybe think about ways in which money flows out of the system. In other words, monies that respondents are paying that are not going to claimants. In terms of, cost savings. For those who practice, Osterlin, for example, seems to be a very expensive issue to litigate, and it's money that's flowing away from not necessarily to claimants, but going to various cottage industries, for lack of a better term. We're looking for ways of corralling costs.
Okay. All right. Thank you. Anyone else? All right. Well, I thank you all again for being with us and participating. Yeah, we will we'll share the proposals, and you're welcome to comment on them or make your own proposals, and we'll have a more in-depth discussion when we meet again, which will be November 28th at noon. And if there's nothing further at this point, yeah, go ahead, Brooke. You're on mute.
I'm sorry. I have a quick question,
Sure.
just for clarification, for Bud. Is the proposal your own personal opinion, or is it the opinion of the Connecticut Bar Association? Like, are you're representing them, or we're just?
That's a great question, but no, it's my own opinion, and I know we want to get off this call, but the process was, and correct me if I'm wrong, Nathan. Nathan came up with a list of virtually everything he's heard from every claimant's attorney about complaining about the act. And we went over this very, very long list and tried to narrow it down to things that were either the most egregious, impacted the most people, or impacted the most severely injured people. And that's kind of how the list came about. But it is me. I'm not speaking for the CBA.
I'm also wondering if we could get some background information on Connecticut compared to other states, because I'd really like to see, the data on what is the case for Connecticut not being sufficient.
Do you want to limit it to our region, or would you like to go further?
Probably New England, and New York and New Jersey, and maybe Pennsylvania would be helpful. Like this region, that would be very helpful.
Okay. Yeah, we can do that.
The Labor Department used to put out every 2 years a chart that charted all of the workers' comp acts and the various benefits, and they stopped doing that. I don't know if they ever started doing that again.
Okay, we can check with them.
And that's it
This
too.
is the Federal Labor Department. I'm sorry.
Could we add to that list? I know a lot of our savings did come from the medical payer plan capping medical doctor fees. So it's not just, when we do workers' comp funding, it's not just the funding that goes to the people, it's the funding that goes to the medical provider. If we could just maybe cap which states have provider fees and which states don't.
Okay. All right. Nate?
Yeah, just quickly to Brooke's point, NCII and the Workers' Compensation, I think it's called Research Institute, they have lists of each state which summarizes all the different benefits, max rates, total disability limitations, permanency, specific things like that. And you have to sign up for those. But to Bud's point, there used to be a list that someone would get and would circulate it every now and then. So if anyone has access to those perhaps the chairman's office might have that. Maria. So
Sorry, I don't think, I mean, we do get information from NCCI and WCRI. I don't know if it's broken down the way what Brooke is looking for. I can certainly look back to see what I've gotten from them recently.
Okay. Right. No, and I agree that would be instructive. So we'll attempt to do it, whether we're able to do it in-house or go outside to get the information, but we'll work on that for sure.
Thank you.
No, you're welcome. Anything else before we adjourn? All right, again, our next meeting will be November 28th at noon on Zoom. We'll have agendas and links out to everyone in advance of the meeting. And we will also get out to you the proposal that Nate and Bud put out. And then what I would ask is that we not create a massive email chain commenting back and forth on that, but rather send individual proposals or hold comments until we meet again. Okay. All right. With that said, if I could have a motion to adjourn. Representative Conley, second by Representative Ackert. All in favor?
Aye.
Opposed? Motion carries. And again, thank you all very much, and we'll see you back here on the 28th.